Welcome to HNS online law classes. According to Civil Procedure Code, under that you are going to study what is jurisdiction and kinds of jurisdiction. So here in this presentation, I am discussing what is jurisdiction of the court, explain the kinds of jurisdiction. The fundamental principles of English law that wherever there is a right, there is a remedy. Ubi jus ibi remedium has been adopted by the Indian legal system also. In fact, right and remedy are the two sides of the same coin and they cannot be disassociated from each other. Right and remedy are the two faces or two sides of the same coin. They cannot be disassociated from each other. A litigant having a grievance of a civil nature has a right to institute a civil suit in a competent court, civil court, unless its cognizance is either expressly or impliedly barred by any statute. Jurisdiction may be defined to be the power or authority of a court to hear and determine a cause to adjudicate and exercise any judicial power in relation to it. So, in other words, by jurisdiction is meant the authority which a court has to decide matters that are litigated before it, or to take cognizance of matters presented in a formal way for its decision. So, thus, jurisdiction of a court means the extent of the authority of a court to administer justice prescribed with reference to the subject matter, pecuniary value, and local limits. In Official Trustee versus Sachindra, after referring to various decisions, the Supreme Court observed from the above discussion, it is clear that before a court can, to be, can be held to have jurisdiction to decide a particular matter. So it must not only have a jurisdiction to try the suit brought, but must also have the authority to pass the orders sought for. It is not sufficient that it has some jurisdiction in relation to the subject matter of the suit. Its jurisdiction must include the power to hear and decide the question at issue, the authority to hear and decide the particular controversy that has arisen between the parties. Basis to determine jurisdiction. It is well settled that for deciding the jurisdiction of a civil court, the averments made in the plaint are material. To put it differently, the jurisdiction of a court should normally be decided on the basis of the case put forward by the plaintiff in his plaint and not by the defendant in his written statement. Thus, in Abdullah versus Galapa, the plaintiff filed a suit in the civil court for declaration of title and for possession and mesne profits, treating the defendants as trespassers. The defendants contended that the civil court had no jurisdiction since he was a tenant. Negotiating the contention of the defendants that the Supreme Court observed there is no denying the fact that the allegations made in a plaint decide the forum. The jurisdiction does not depend upon the defense taken by the defendants in the written statement. On a reading of the plaint as a whole, it is evident that the plaintiff appellant had filed a suit giving rise to the present appeal, treating the defendants as trespassers as they denied the title of the plaintiff appellant. Now, a suit against the trespasser would lie only in the civil court and not in the revenue court. We are, therefore, of the considered opinion that on the allegations made in the plaint suit, the suit was cognizable by the civil court. There is no kinds of jurisdiction. Jurisdiction of a court may be classified under the following categories. First one, territorial or local jurisdiction. Every court has its own local or territorial limits, beyond which it cannot exercise its jurisdiction. These limits are fixed by the government. The district judge has to exercise jurisdiction within is over the territory of a state within which it is situated and not beyond it. Again, a court has no jurisdiction to try a suit for immovable property situated beyond its local limits. Pecuniary jurisdiction. The court provides that a court will have jurisdiction only over those suits the amount or value of the subject matter of which does not exceed the pecuniary limits of its jurisdiction. Some courts have unlimited pecuniary jurisdiction. Example, high courts and district courts have no pecuniary limitations, but there are other courts having jurisdiction to try suits up to a particular amount. Thus, a presidency small causes court cannot entertain a suit in which the amount claimed exceeds 1000. Pecuniary jurisdiction. The court provides that a court will have jurisdiction as to subject matter. Different courts have been empowered to decide different types of suits. Certain courts are precluded from entertaining certain suits. Thus, the Presidency Small Causes Court has no jurisdiction to try suits for specific performance of a contract, partition of immovable property, foreclosure or redemption of a mortgage, etc. Similarly, in respect of testamentary matters, divorce cases, probate proceedings, insolvency proceedings, etc., only the district judge or a civil judge, senior division, has jurisdiction. Original and appellate jurisdiction. The jurisdiction of a court may be classified as original and appellate. In the exercise of original jurisdiction, a court entertains and decides suits, and in its appellate jurisdiction, it entertains and decides appeals. Municipal courts, courts of civil judge, and small causes courts possesses original jurisdiction only, while district courts and high courts have original as well as appellate jurisdiction.